Bowers v. Hardwick in 1986 and Lawrence and Garner v. Texas in 2003 had very similar facts and posed the same constitutional question for the court. However, the outcomes of the cases were completely different. The Bowers case originated in Atlanta, Georgia. The Lawrence and Garner case in Houston, Texas. In both cases, local police officers responded to anonymous calls reporting burglaries of private residences. However, when police officers arrived at the specified addresses, they found gay male couples involved in acts of homosexual sodomy. In both cases, the police arrested the men and charged them with violating the respective state sodomy laws. In both cases, the men were convicted at trial. Both cases ended up before the United States Supreme Court on appeal. In both cases, the convicted men argued that the respective state sodomy laws violated the constitutional right to privacy that the Supreme Court had delineated in Griswold v. Connecticut, that the constitutional right to privacy could be and should be construed to protect an individual's right to engage in his preferred sexual behavior. In the Bowers case, the Supreme Court upheld the Georgia sodomy law on the grounds that they could find no language in the Constitution that could be construed to protect the supposed right, and that the state of Georgia had an overriding and compelling interest in criminalizing sodomy. Some contend that Bowers should be understood in the historical context of the AIDS epidemic, which was in a relatively early stage in 1986. In Lawrence and Garner v. Texas, the Supreme Court reversed its position and invalidated the Texas statute and presumably those of other states, holding that, quote, the Texas statute furthers no legitimate state interest which can justify its intrusion into the personal and private life of the individual, end quote.